Hello aspirants, welcome to Introspection IS. So in today's series we are going to discuss previous year question from the topic preambles and citizenship. In this topic there are less, or I can say that only one questions from a citizenship till the period has been asked in the last 14 years, and preamble has been the majority been asked in this sections. So let's start the discussions. So we will start the discussions previous year questions from preambles and citizenships. So the first questions which was asked in 2021 from the preamble and says, what was the exact constitutional status of India on 26th January 1950? So it tries to and it want to ask that the constitutional status at the commencement of constitutions, right? So as we know that today the constitution states that India into a sovereign, socialist, secular, democratic republic. This is a current status of constitutions, but it is asking when it was implemented or enforced in 1915. What was the current status? So does the India at the time of 1950 was a democratic republic? No, though democratic republic is there, but it is not solely democratic republic. And as we all know that the two term, that is a socialist and secular, were added by the 42nd Constitutional Amendment Act 1976. So the what we see today as an status of a constitution was not the originally status. So original status are different. So originally the Indian constitution has a sovereign, democratic and republic. So the B options, that is a sovereign democratic republic, is a correct answer. Clear? It is not secular. The secular and socialist term was added by the 42nd Constitutional Amendment Act 1976, and we can say that this is a factual question, fact-based questions. So if you see the preamble, which is reflective of an essence of Constitution of India. So original preamble adopted by the Constituent Assembly in 1949 declare India as a sovereign democratic republic. By the 42nd Constitutional Amendment Act 1976, enacted during the emergency, the word socialist and secular were inserted. So the preamble now reads sovereign, socialist, secular, democratic republic. It is a current status. Current status of constitutions, but originally it was a sovereign democratic republic. Clear? Let's move to the next questions. So next question asked was in 2020. So preamble to the Constitution of India is, now it is asking the preamble, what does the preamble stand for? The constitutions, right? So preamble is a part of constitution. Yes, it was later decided in the Keswar and Bharti that preamble was a part of constitutions, but has no legal effect. Yes, this is also true that it has no legal effect. Let's move to the another options. Preamble not a part of constitutions? No, it is not true. So preamble is a part of constitutions. So B cannot be the answer. C, part of a constitution and has the same legal effect as the another part? No, it is not having a same legal effect. Now this legal effect means that, as we know, that preamble is not enforceable in court. Not enforceable in court. So it is not enforceable, having so no legal effect. No one can move to the court, and judiciary has nothing to do with the implementation of the preamble. So we can say it is not having any legal effect. So C is not true. Why? Because it says that same legal effect, so it has not legal effect. Now our answer may be A or D. So let's analyze the option D, whether D can be answer or not. So a part of constitution, yes true. Has no legal effect, yes true, as A suggests. And it says independently of other part, yet it is also true. So because of this, the last portion added to the answer option D. So it is an appropriate answer. D, we can say that D is an answer to the questions which says that preamble of to the Constitution of India is a part of Constitution decided by case 1 under Bharti case, has no legal effect. It means not enforceable, not enforceable, and independently of other part, it means it is neither a source of power nor a restrictions. So it has nothing to do with the other part. It is only stating the status of the constitutions. Clear? So we can say D is the most appropriate answers. Now if you see that the Supreme Court in Berubari Union case in 1960 held that preamble is not a part of the constitution. So this was held in Berubari case. It further said that preamble can be used as a guiding principle if a term in any article of the constitution is ambiguous, that is not clear or has more than one meaning. So this was stated in Berubari case, right? So according to Berubari, we can say that it is B may be the answer, right? Or that is not a part of the constitution, which is said by the Berubari. But this judgment of the Supreme Court, which was given in 1960, was reverted or overturned by the Supreme Court its own judgment in 1973 under case 1 and Bharti case. So in case 1 and Bharti case in 1973, the Supreme Court reversed its ruling under the Berubari case and held that preamble is a part of constitutions and can also be amended under Article 368 of the constitutions. Preamble therefore is a part of constitution, and as we know that this is a most important case in Indian constitution history, right? Why? Because by this judgment the doctrine of basic structure emerged, and it has decided the uh, power of power of parliament under Article 368, whether the parliament is has absolute or limited power. So it says the parliament power under Article 368 is limited, though it has power to amend any part of the constitution, including the preamble and part 3 of the constitution, but that has to be restricted through the doctrine of basic structure. So because of this, the Keshwan and Bharti case becomes a most important part also. So this has decided that preamble is a part of constitution, and it also falls under the power under 368 that parliament can amend the preamble along with the constitutions. Preamble states that the objects of the constitution and is not enforceable in court, thus have no legal effect independently of others. Clear? So it has not legal effect because it is not enforceable in the court. This we have already discussed. No legal effect independently of other parts. Clear? So the preamble does not grant rights or enforce duties. As I have said, it has neither a source of power not a restrictions, and it cannot be enforceable in a court. So not legal in effect means not enforceable in court, and independently of other part, it means it does not give any right to anyone, or it enforces duties. So according to the options, D is our answer. Clear? So moving to the next question. Now next question was asked in 2017. So it says the question says that which one of the following objective is not embodied in the preamble of the Constitution of India. So it talks about the objective, right? So it says though the first objective is there in the preamble, liberty of thoughts. Yes, there is a liberty of thought. liberty of economic, liberty of expressions, liberty of belief. Yes, it has a liberty of thoughts, liberty of expression, liberty of belief, but it does not have an economic liberty. It does not talk about economic liberty. Clear? Now if we see the preamble, so preamble has a four uh, dimensions. The four dimensions. The first dimensions of the preamble is source of power. So preamble first talk about a source of power to constitutions. Second dimensions of the preamble is nature of state. Nature of state. India. It talks about nature of state means India. Third dimensions of preamble, it talks about the objective of the constitution. And the fourth talk about a date of adoption of constitutions. So these four informations we can find under preamble, right? So first it talks about source of power. So who are the source of power? The people of India. People of India. So people of India are source of power. How we can say that the people of India are source of power? So if you see the opening statement of preamble, which says that we, the people of India, this is the first line opening of the preamble, and the last line says give, adopt to ourselves this constitutions. So this line indicates that the it is the people of India who has been amended, who has been made this constitution, who has adopted this constitution, who's given themselves to the constitutions, which says that the peoples are ultimate source of power to the constitution. So from where the constitution is gaining power, the constitution is gaining power from the people of India. It is not gaining from the parliament, it is not gaining from constituent assembly, it is not gaining from power from judiciary or anything. All these are the subordinate to constitutions, but constitution is having power from the people of India, right? This is the first objective, sorry, not objective but dimensions of preamble. Now if you see the second dimensions of preamble, that is nature of state. So what nature of state India would be? So India is a sovereign, India is socialist, India is secular, India is democratic, India is a republic. So India is a sovereign nation, India is a socialist nation, India is a secular nation, India is a democratic nation, India is a republic nations. So these of nature of the states is also given under the constitutions. If we go through the constitution, we can find that India is of a sovereign nature, India is of a socialist nature, India is of a secular nature, India is of a democratic or republic nation. Now if we talk about the objective, so it has an objective of justice. It wants to establish justice, it wants to establish liberty, it wants to establish equality, it wants to establish fraternity. So these are the objective what the constitution want to establish through preamble stated the objective of the constitutions which wants to establish. Clear? Now if we talk of the date of adoption, so it says that on the 26th of November 1949 we have adopted, given to this constitution to ourselves. So these four dimensions we can find under the preamble. So anyone who can go to the preamble can find these four of the dimensions of preamble. Now the question is about an objective of the preamble. Now this objective talks about a liberty. So if you see the liberty, so here if you see the objective of the constitution as mentioned in preamble is the justice. So which type of justice? It should be a social justice, economic justice and political justice. It is talking about the liberty of thoughts, liberty of expressions, liberty of belief, liberty of faith and liberty of worship. But it does not talk about a liberty of economic. This economic is given under the economic justice. So the constitutions, the preamble talks about economic justice. It does not talk about economic liberty, right? But it talks about the liberty of thoughts, liberty of expressions, liberty of belief, liberty of faith, and liberty of worship. Clear? So this is an answer to our questions. Right? Now we are moving to the next question. Now the next questions asked in 2017. So the question says, the mind of the makers of the Constitution of India is reflected in which of the following? Right? So mind of the maker. Now here we need to understand that key to constitution it wants to ask. Key to constitution it wants to ask. Right? That make what type of constitutions the framers want to establish in India is shown in which part of the constitutions. That from there we can say that from that part we can say that okay, the makers, the framers want this type, the kind of India which they have thought of, or which they have fought of, for the under in British rule, against the British rule, they want to establish such kind of India. That all the thought process, all the struggle during the freedom struggle, freedom fighters of their framers of the constitutions, all can be seen in which part of the constitution, that from where we can say that this is a part that how our constitution India is going to look up. So that can be seen. So the mind of the maker, it may be a key to the constitution also, we can say that is an preamble, where we can see all the relative provisions that how our India is to be. Now if we move to the previous slide, so here we can say that preamble, the framers shows that constitution would gain power from whom? It will gain power from the people. How would be the India as a nature of state? So India would be sovereign, socialist, secular, democratic, republic. What we want to achieve through constitution? So we want to achieve a justice, liberty, equality, fraternity. So these all shows that what type of India has been dreamed by the framers of the constitution. So their mind has been speaking in preamble of the constitutions. Is it clear? So if you see, the preambles embodied the fundamental values and philosophy of the constitutions, including political, moral, and religious values that we have seen already. Preambles reflect the vision and aims of the founding fathers and states' goal for the nations. This we have already been written. The name, that means objective they want to establish: equality, fraternity, liberty, justice, right? According to Sri Aladi Krishna Swami Iyer, a member of a constituent assembly, the preamble expresses what the framers have thought or dreamed of. It's clear? So this we can say that the mind of a preamble, key to the key to the constitution is a preamble. Clear? So now let's move to the next question. So next question is asked in 2013, was asked in 2013. Now this question says that economic justice as one of the objectives of the Indian constitution has provided in. Now economic justice, as we have seen that justice, this economic justice is one of the objective, so that can be found in where, in which part of the constitution? The first, it is found in preamble, so this two may be our answer, so this cannot be the answer. And let's see whether the first two options works out now, right? Preamble and fundamental rights, preambles and directive principles. Economic justice is talking about the economic justice. Fundamental right has an individual liberty, it is talking about the individual liberty, it is not talking about the justice or economic justice, or clear mention in the constitution is not fundamental rights, but the preamble and directive state of uh, directive principle of state policies, that is article 39, talks about an equitable distribution of wealth, then concentration of wealth, violation of concentration of wealth, which is talking about economic justice. So our answer is B. Now if you see, so the preamble directly mentioned the economic justice. Objective of constitution as mentioned in preamble, that is justice, social justice and economic justice. So here we can say that the preamble is a clear indication of justice that is explicitly mentioned in preamble. Now if we talk about the article 39, which is a part of directive principle of state policies, that is part 4th of the constitutions, part 4th of the constitutions. So it says that the state shall in particular direct its policy towards securing that the citizens, men and women equally, have the right to adequate means of livelihood. It is means this is trying to acquire the economic justice among men and women equally have the right to adequate means of livelihood. Then says securing that the ownership and control of material resource of the community are so distributed as best to serve the common good. Yes, it is also saying that this should not be concentrated at one place, or it should not be, but it should be distributed, equal distribution. It is talking about the equal distribution of wealth, economic. It is talking about the economic justice. 39 clause C talks about securing that the operations of economic system does not result in concentration of wealth and means of productions to common determinant. Yes, it means that it is trying to avoid or prohibit concentration of wealth or providing privileges in terms of economic. So it is also talking economic justice. Now clause D of the 39 talks about that there is an equal pay for equal work for both men and women. Yes, it is providing equality in terms of economic. So we can say that Article 39 particularly talks about an economic justice, and the preamble there can be explicitly mentioned in the preamble. Clear? So answer to this question is preamble and directive principle of state policies. Okay? Let's move to the next question. Now the next question, it was asked in 2021, and this is related to citizenship. As I have stated at the behest of this discussion, that there is only one questions particularly related to citizenship, that is part second of the constitution is asked, and this was asked in 2021. Now let's see the questions. With reference to India, consider the following statement. So there are three statements given. Now we need to find the correct statement, right? So there is only one citizenship and one domicile. Yes, it is true. As we know, we follow a British model. In British model, in terms of citizenships, from we have taken one citizenship. Unlike the USA, we do not have a separate citizenship for union and state. So we have a single citizenship for union and state. It means irrespective of place of residence or place of birth, every citizen is loyal towards union, that is loyal towards India, not towards their respective respective states. Is it clear? Okay. So there is only one citizenship and one domiciles. Now a citizen by birth only can become head of the state. No, this is false. This is incorrect. Why? So this provisions, if it for to understand this provision, we need to compare India and USA. So criteria to hold head of the state, qualification of head of the state. So in India, it is required that if anyone wants to become a head of the state, he has to be a citizen of India. Irrespective of by which or through what mechanism he has acquired the citizen of India, there will be no effect of that. Only that he becomes a citizen of India, so he is eligible to head of the state. But in USA, it is necessary that a birth, or you can say that only citizen born citizen can held or become head of a state positions. So this is true in sense of America, but not in true in sense of India. So we said second is incorrect. So this cannot be our answer and this cannot be our answer. So now our answer can be A or C. Now if you see the C, a foreigner once granted citizenship cannot be deprived of it under any circumstances. This is also incorrect because this is an absolute. and absolute is not true in any sense. So it says that a foreigner through naturalizations, a foreigner is can acquire through naturalizations. So if a foreigner acquired a citizenship through naturalization, cannot be deprived of, no, it can be deprived. So this is also incorrect. So our answer correct is only one, right? Only one. Now if you see the explanation to this, so if you see about the citizenship, the Indian Constitution provides for only a single citizenship, that is an Indian citizenship. No state citizenship is available in India like America. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. Also, when Indian citizens voluntarily acquires the citizenship of another country, his Indian citizenship automatically terminates. There is only one domicile allowed in India. Domicile certificate can be made only in the one state or UT. Judiciary declared that there is no separate domicile for each state and there is only one domicile for entire country. In India, both a citizen by birth as well as a naturalized citizens are eligible for the office of president that we have discussed. Thus, naturalized citizen can become the head of the state. So this is the first two statement we have discussed. Now if you see the third statement, a foreigner who has been earlier granted Indian citizenship can be deprived of his citizenship. His Indian citizenship can be terminated by the central government if he has obtained the citizenship by fraud, if he has shown disloyalty to the constitutions, if he has unlawfully traded or communicated with the enemy during war, if he has within 5 years after registration or naturalization has been imprisoned in any country for 2 years, and if he has ordinarily resident out of India for 7 years continuously, so his citizenship would be terminated. Right, so not only the foreign citizenship, so any citizen of India, his or her citizenship can be terminated, irrespective of through what mechanism the person has gained the citizenship. There is nothing to do with the gain of citizenship. So if all these conditions satisfied, not only to foreigners only but any citizen of India, if the person is obtained if the person obtains citizenship through fraud, so not only foreigner but also the other citizens can also be his or her citizenship can be terminated. Clear? So this is a question from citizenship. So this is all from this part, that is preamble and citizenship. Hope you like the this series. So please like, subscribe and comment. Thank you.